have to start recording in live. And
Thank
we are live.
Thank you very much.
You
Yes,
were
could I
reading,
ask
you were reading from that page, Mr. Harrison.
Pardon me?
You were reading from that page when you went
Yes.
off.
Yes. Yes. What I just asked you to do at this time. Well, I'm going to ask you just to bear with me, Sir Johnson. I'm going to read this document, and I wish to make reference to the report where reference is made to you. So just bear with me in terms of my reading. I'll just continue where I left off. Mr. Virgil instructed Mr. R. Mottier to send the deeds of the land to David Wilkinson, who was representing Pearman. This Mr. Mottier did. There is no doubt in Mr. Mottier's mind that the man who gave him these instructions was John Virgil. He saw Virgil prior to this date and drew up Virgil's will in 1964. Mr. Mottier still had in his possession two. Sales agreement dated 11th January 1969. This was the original agreement. Agreement had original signatures by Pearman, Virgil, and witness Duers. I can't make out that part.
I obtained this document on receipt.
Thank you very much, Mr. White. I obtained this document on receipt. TC 10. On December 26, November 1975, I saw Algernon Duers. I recorded a statement from Duers and obtained samples of his handwriting. Duers stated that he gave one signature to Russell Pearman in a taxi up at Government Gate, Pembroke, one morning in 1969. He's sure he only gave one signature. On the 15th December 1975, I saw one John Emmanuel Augustus. He could only say that he did buy land in Sands Parish from Russell Levi Pearman in 1969 for £18,000 sterling. Transaction was handled by Wilkinson's office. Property was later sold to John W. Swan in 1970 for £60,000 sterling, in bracket, an elderly man whose memory is not good. On TC 12, on 8th December 1975, I saw Michael Collier, Bank of Butterfield, receive copy of fixed deposit account of John Augustus Virgil. Also receive original savings account signatures of Virgil. On 29th January 1976, Detective Inspector Waddle did a preliminary examination of a signature of Virgil and Duers on sale agreement against samples. His opinion is that Duers' signature and sales agreement are not similar. The signatures of John Virgil on the sales agreement are similar. He suggests a proper examination by an expert should be done if the case warrants such action. It cannot be done in Bermuda. On the 28th January 1976, I saw David Wilkinson at his office at Sophia Church Street. I explained the nature of my inquiries and asked if he had any original document relating to the transactions between Pearman and Virgil and Pearman and Augustus. He stated he would not keep original documents as they would stay with the papers to the property. I then saw a sales agreement dated the 19th February 1969 in the file he had. I asked him if he had the sales agreement for transaction between Pearman and Augustus. He answered yes. I asked for the document for examination. He refused. I asked for a copy. He refused. I asked him the date of the agreement. He took some time to answer, and I said, would it be 19th February 1969? He said yes. Mr. Wilkinson admitted that he had drawn up the conveyance for sale of property from Virgil to Pearman on the 15th April 1969, and also drew up a conveyance between Pearman and Augustus on the same date, 15th April 1969. I asked him if he didn't think it was odd that Pearman should agree to sell the Virgil property on 19th February 1969 for £18,000 before he actually bought the property. A copy of this conveyance in possession of the police has no signatures thereon. Mr. Wilkinson did not know John Virgil prior to 15th April 1969. Again, on April 15th, 1969, another conveyance was drawn up by David Wilkinson for actual sale of the land from Pearman to a Mr. John Augustus for £18,000. The original conveyance has not been found to date, and no copies have been found. However, both of these conveyances are in existence as they have been sent to John W. Swan Limited by Peter Smith's office, see TC 8. Also mentioned the second conveyance between Pearman and Augustus is mentioned in Exhibit TC 4. Again on 15th April, David Wilkinson's office sent letter TC 5 to Sands Parish Vestry notifying change of ownership of land from Pearman to John Augustus. Statement of complainant Barbara Brown, TC 14. She gives background re Algernon Duas and also states that Mr. David Wilkinson informed her by telephone that Pearman had bought land from her uncle and that he, Wilkinson, had handled the transaction and that Pearman was a crook. Wilkinson also told her this on a second occasion, namely that Pearman was a crook. Almost unusual comment from the lawyer dealing with the transactions relating to Virgil's property, and a different story than he gave to police. Conveyance dated 15th April 1969, TC 3, shows that Virgil received £7,000 on that date. Mr. Wilkinson stated that a check was made out to Virgil on that date for a sum just over £6,800. Copy of fixed deposit account of John Augustus Virgil from Bank of Butterfield shows £6,800 deposited to Virgil's account on 4th July 1969. Bank cannot find record of check. Mr. Wilkinson should have a check and stated that he could find it. Conclusion. It is possible that John Virgil never signed the conveyance dated 15th April 1969 at David Wilkinson's office. He was not known to Wilkinson, and indeed Mr. Pearman could have brought someone also instead. Without the original conveyance and examination of Virgil's signature on that document, nothing further can be done at present. Mr. John W. Swan has started a search for this document without success to date. I am of the opinion that a civil suit should be instituted against Russell Levi Pearman for failing to make full something of value to Virgil land. I just pause here. Sir John, in relation to the conclusion, I've gone through just to read and to allow you to refresh your memory. In terms of the conclusion that is shown there, do you recall starting a search for this document of the conveyance without success?
If a person came to me and asked me to look for something, I would have extended the courtesy of looking. Keep in mind that, we were dealing with hundreds of transactions at that particular time. So, to go and ask me to detail specifically about that particular transaction, I would not, because I didn't regard it as out of the ordinary. So I would not have had any sort of specific recollection in the process.
Okay. So the question I'm asking you now, having said all that, the conveyance that is contained in JS1, that document is the one that relates to the transaction. That is the only document that you are aware of.
Mr. Harrison, you put to Sir John the police report, which says that John W. Swan Limited gave them a receipt for two other documents dated the 15th of April, 1969. So you're asking him to refute your own evidence that you, not the evidence, but the report that you put in.
Well, I'm not sure I clear your question, but when we were disconnected, I had started to ask then, which I think I realized I didn't complete. I was asked about other documents, and I think that's where the error.
That didn't come through, Mr. Harrison. Sorry.
Yes, I'm sorry. I had started to ask about other documents. My apologies. When we were cut off. In relation to this transaction, Sir John Swan, do you have in your possession any other documentation other than the documents which are referred to in JS1?
Do I have it in my possession now, or did I ever have it in my possession?
Do you have it in your possession in your office? Do you have a file with any other documents relating to the transaction?
Absolutely no.
Thank you. In relation to this police report that I've just read to you, which is an exhibit as stated CNLB 16, do you have any concerns? Is your answer still no in terms of concerns regarding what the police officer here has outlined in terms of certain gaps regarding the transactions that are mentioned in what I just read to you?
My statement is, with regard to my dealing with the transaction, the answer is no. If there's anything that concerns Mr. Pearman and Mr. Virgil, it's not for me to make a judgment on.
Thank you very much. Now, are you aware of a caveat being lodged by Mrs. Barbara Brown at any time in relation to the development of the land that you developed, the land that is the subject of the documents JS1? Are you aware of Mrs. Barbara Brown lodging a caveat on the...
Mr. Harrison, just to ask you a question. Caveats are lodged in estates. They're not lodged against development. I think you're conflating something. I believe you're referring to the caveat lodged by Mrs. Brown against the estate of the late former Commissioner of Police, Mr. Lenny Edwards.
Thank you very much. And the question is, Mr. White and Sir John Swan, and in relation to the late Mr. Edwards, did you sell one of the lots you sold and bought and developed? Was that one owned by the late Mr. White?
Edwards, Mr. Edwards.
Mr. Edwards.
Yeah.
I would have to go back into the file. I have no recollection of the people I sold the property to. That was one of many, many, many transactions I did at the time.
Sir John Swan, in preparation for this matter, have you tried to recollect the circumstances around the sale and the persons to whom you sold?
Why would I do that when I felt as though I conducted a legitimate transaction, as I've done with many transactions?
Because you may face questions from persons. That is one answer, but you have not. Is that so? You have not. You have not. I'm just going to ask you if you could just shift your camera a bit. You're a little out of the frame. I'm seeing it more of Mr. Nicholas Swan, and I'm seeing you. Thank you.
What is the question again, please?
The question is, in preparation for this hearing, did you try to reacquaint yourself with any of the facts surrounding the transaction in relation to JS1?
Well, as I read in my statement, how the transaction occurred in my purchasing of the property, but I did not go back into the details as to whom I sold the property to, or who the property was transferred for the purpose of getting mortgage on the property, or who the property was transferred to the ownership. And the ownership then could have changed because the people who bought it might have then sold it to somebody else. So the answer is I did not do research on the details of people who now own the property or might have owned the property during the time leading up to my disposing of the property.
So I'm certainly not being facetious. So we're going to rely then on your memory going back 30, almost 50 years.
Yeah, you can't rely on my memory.
Mr. Harrison, you did ask the witness if he had any documents in his office, and he gave the answer no. What else could he rely on?
And that was obvious. Thank you, Mr. White. So that's why I was saying the obvious. Thank you so much. So the question that I'm going back to, are you aware of any caveats being lodged, whether to a lot or to the estate? Are you aware of any caveats lodged by Mrs. Barbara Brown in relation to the land which you bought from Augustus, which you developed and sold to persons?
What do you refer to as caveats?
It is a document lodged in the Supreme Court or in a court, whatever court there is.
Supreme Court.
Thank you.
Well,
Indicating, and I'm just going to ask the secretary to bring it up for me. It's not an exhibit, but it had been shared with council. I believe it had been shared with you some weeks ago, the caveat. But rather than answering questions that I'm not here to do, Sir John Swan, it is just a document giving notice to persons not to deal with the land, and if they try to deal with it, it is just a bar to so do. That's my simple layman's term. But the question is, are you aware at any time of Mrs. Barbara Brown seeking to lodge a caveat in relation to the property which you had bought, which you developed and subsequently sold?
no.
Have you had any discussion over the years, any interaction with Mrs. Barbara Brown in respect of concerns she raised in respect of your acquisition of the land in question?
But only through the court process, which occurred on a number of occasions, as I spelled out, as I said in my statement, my opening statement.
Could I ask you, Secretariat, could you take me to the statement of Mrs. Barbara Brown? The exhibit number, it is not the recent statement, it is I'm just going to ask to take me to her statement.
It's
The exhibit.
it's TC 16 behind the police report in the bundle from the Browns, if that's helpful.
Thank you. So this statement is statement of Barbara Lucille Brown, occupation laundry maid, dated the 9th February 1976. Signed Mrs. Barbara Brown, signature witnessed by T. Cassin, DS 55. I'm a married woman and I work as a laundry maid in my own business. John Augustus Alexander Virgil, who died in 1972, was my uncle. For a number of years before his death, I looked after him financially wise. John was an alcoholic since about 1959, and during the time before his death, he lived like a hermit. He would not look after himself. Sometime before 1970, I received a telephone call from Mr. David Wilkinson. He asked for Mrs. Brown. I said, "That's me." He said, "I'm calling to tell you that Mr. Pearman has bought some property from your uncle, and I've only done this transaction for Mr. Pearman. He's a crook, you know." I said, "Who, Mr. Pearman?" And he said, "Russell Levi." I said, "Oh," and that was the end of that. A couple of months later, Mr. Wilkinson came into the hog penny where I worked. He called me over and asked me if I was the niece of John Virgil. I told him I was, and he said, "Did you hear any more about that property matter?" I said, "No." He then said, "That man is a crook, That's all that was said. The next time I saw Mr. Wilkinson was about 2 or 3 years later, when I saw him about a matter between my husband and myself. He did not say anything then about my uncle's property. In 1972, when my uncle died, I was a beneficiary of his will with 6 other relatives. I found out then that my uncle's property was gone, yet there was a little money left. I went to a number of lawyers, but I could not get any satisfaction from them. All I got was excuses. I first went to Walter Maddox. He suggested that it would be cheaper if we did the groundwork, so I did. When I brought details to him, he could not take the case because he would have to prove that my uncle was insane when he sold his property. He never said he was insane, only that he was an alcoholic and a sick man. We then went to Ann Cartwright, Walter Robinson, Louis Brown. I got nothing from any of them. Oh yes, I went to Chandler too, but apparently I didn't have enough information. I then dealt with Mr. Michael Mello. When I was cleaning out my uncle's room, I got a copy of a sales agreement between my uncle and Russell Pearman. I saw that a man named Duers had witnessed the agreement, so I went through the Duers in the telephone book and found this man, Algernon Duers. I arranged to see him and I took Miss Eunice Ming, Glenn Ming, both beneficiaries of my uncle's will, and a cousin, Genevieve Hollis. I saw Mr. Duers at his house and asked him if he knew John Virgil of Hamilton. He didn't know him. I showed him the sales agreement and he opened it and he agreed it was his signature. He then said he gave his signature to Russell Pearman in a taxi at Government Gate. I asked him if anyone else was present, meaning my uncle, and he said no. He said he saw a man, Smith, over the other side of the road. This man, Smith, is a Mason. After this, I went to Mr. Mello and then I went to see the police. Mr. Mello was at the time waiting for some documents from John W. Swan, and he had been waiting for about 5 months for these documents before I went to the police. My uncle's land was in Sands Parish. Thank you very much. I'm asking you again, Sir John Swan, and I'm going to ask the Secretary to take me to the other statement of Mrs. Barbara Brown. I'm going to ask you if you have had any contact other than in the Supreme Court with Mrs. Barbara Brown.
I've had no contact with her.
Okay. I ask you to take us, Secretary, to other statement. This statement is dated the 25th of January 2021, signed Barbara Brown. The purpose of this statement is to facilitate communication between the Commission of Inquiry into Historic Losses of Land in Bermuda and myself, Mrs. Barbara Brown. I am one of 7 beneficiaries of the estate of my late uncle, John Augustus Alexander.
Mr. Harrison, not to interrupt you, but are you going to read the whole statement, which is already before the commission? Why not go to page 4, which is what you want to ask him about?
Thank you. But what has been happening is that Sir John Swan, each time I've asked him a question, he has no recollection. I'm just trying to assist him to refresh his memory by reading what is contained.
Well, I think what you should read is paragraph 18 and what she says about that. And that would assist him in his memory recollection. The rest of the stuff doesn't refer to him at all.
Sir John Swan, do you recall this statement given by Mrs. Barbara Brown? That would be easier.
Which statement you're talking about?
The one that's projected on the screen. Do you recall a statement she gave to the Commission of Inquiry recently?
Well, I haven't had time to read it.
So we can't see
So,
it.
Mr. White, that's just my point. That's why I was reading it to him, so to refresh his memory. But
Well, it's not even on. It's not even showing on the screen at the moment. That's the point. The paragraph in question is not even up properly on the screen. We don't even have it, so we can't.
Respectfully, Sir John Swan, are you seeing what are you seeing on the screen?
With a statement, purpose of the statement is
Okay.
facilitate communication between the Commissioner of Inquiry and the historic landlord. Is that what you're talking about?
Yes, and you see it says dated the 25th day of January 2021, signed Barbara Brown. You're seeing that, are
Yeah,
you?
yeah.
Okay, good. Okay, we'll scroll down then.
What do you want to ask me?
I would like to read it first before my question, but could you just scroll down for me, please, Secretariat? Slowly scroll down.
It's page 4, Mr. Harrison.
Thank you. Thank you, Mr. White.
Slow down. Whoa. There you go.
Okay. So let me just read the paragraph before. Could you just go back up to 17 for me? So it says, in the late 1970s, I went to the office of Sir Dudley Sperling, a founding member of Appleby and eventual chair of the Bermuda Law Reform Committee. I showed up unannounced at his office to encourage him to address the outstanding estate of my Uncle John. During our meeting, I told him that I would be going to the House of Assembly to complain about the treatment I had been experiencing. He ended the meeting by telling me, the ball is in your court and you had better be very careful with what you say, end quote. Sir John Swan, this is what is on the document, paragraph 18. During 1975, I called John Swan at his home one evening. I wished to speak with him about how he claimed ownership of my uncle's property. I wanted to meet with him to discuss his claim to the land at Spring Benny. John Swan said, I ain't having no meeting with you and don't call here no more. Then he abruptly hung the phone up in my ear. Sir John Swan, the question is now, do you recall having any contact with Mrs. Barbara Brown other than in the Supreme Court?
I do not recall, and nor would I have hung up on somebody. It's not my policy ever to hang up on anybody. So, but I don't recall the conversation, Mrs. Brown. I had with Mrs. Brown, who claims that she called me. I don't have to call the conversation at all.
Okay. And I'm suggesting to you that, in fact, you can't recall, but I'm suggesting to you, in fact, she did call you with regards to concerns she had had.
Well, you're suggesting because she says so.
That is so.
I mean, that's the reason why you are suggesting is because she said.
Agreed. Agreed.
But do you have evidence that she did call?
I'm not going to answer questions, but I'm just sorry, just with respect. I accept your answer that you don't recall. I am just doing another part and putting to you. We don't have to be argumentative. I'm just putting it to you rather than putting a question to me. You could just answer as you wish, but I'm just putting it to you, sir.
I did answer you. I said I do not, and I would not. It's not my policy to hang up on people. That's what I said.
Right, and I had moved on, and I'm moving on. I'm moving on. You're the one who's asked me a question if I had proof, but I have moved on. Thank you. No, thank you, Secretariat. I'm suggesting to you further, Sir John Swan, that Mrs. Barbara Brown had in fact lodged caveats touching and concerning the land that you had bought from Augustus and developed, and it was done to alert the persons in possession of the land that claim was being laid to the said land by the Virgil family.
Mr. Harrison, a caveat's against an estate. It's not against land.
I appreciate the technicality. I'm trying, Mr. Sir John and I take Sir John has indicated a lot of these technicalities. I'm just trying to, rather than being legalese here, to break it down with respect. I'm not trying to dismantle the law. I'm merely asking about a caveat. Let me repeat. Thank you, Mr. White. I'm merely putting to you and suggesting that a caveat had in fact been lodged by Mrs. Barbara White in respect of land which you bought, developed, and sold, the land that is subject to the indenture in JS1. That's my simple suggestion.
Is it your suggestion or is it you're asking me a question?
I'm not asking a question, I'm just putting to you that that is a fact.
It's a fact because it's a fact. If you have the documents that there was a caveat that was issued, you have copies of the caveats that were issued, certified, fine, but they weren't issued against me because my action with Mrs. Brown was through the courts.
Right, and I'm not arguing that, I'm just putting that and moving on. Thank you.
I mean, but anyhow, carry on.
Thank you very much. Now, you had made mention of the instances of court matters, and as I say, I was unable to capture all of it, Mr. White. I hope that you'll share with us a written copy of the document, because I wasn't able to capture all of what was being said. But I trust you could email it to us, Mr. White, or you're not able to. You need to rely on the transcript.
Rely on the transcript. I don't have it.
Okay, sure. Thank you very much. So let us go back to the statement, sir. Can you just go back to the statement then to assist me? You have the statement there, sir?
I can tell you this, Mr. Harrison.
No, not you. This is for Sir John Swan. Go ahead, though, Mr. White.
He referred to the 5 cases which we have supplied to the commission. So the commission secretariat have all 5 cases, and they can project them on the screen if you wish.
No, I don't wish. I'm referring specifically to the statement made in relation to the to the cases. That's what I'm asking you about, not the cases itself.
But what Sir John said about it. Yes.
Sir John Swan, could I take you back to your statement made?
Yeah, I'm here.
Yeah, yes, but could I ask you to direct your attention to the statement? Could you just read for me the paragraph that speaks to the court cases?
Okay, all right. The paragraph that speaks to the court cases. There have been 5 court cases involving the Browns and myself on my company heard on 5 different occasions in the Supreme Court of the Court of Appeal by 3 different justices and the president of the Court of Appeal. And now I can read. You want me to read the cases?
Yes, please continue. Yes.
In 1982, number 252, Justice Martin Ward dismissed no cause of action for want of prosecution. Number 2, 1990, number 226, Justice Mirabox dismissed plaintiffs not having complied with paragraph 2 of the order of this court made on the 3rd of February, 1994. The plaintiff paid the costs to the defendant. Number 3, 1998, number 60, Justice Mirabox, as the application amounted to a fishing expedition. Number 4, civil appeal, 1998, number 16 appeal, the president of the Court of Appeals, Sir James Asworth, dismissed the applicant's failure to comply with the order of the register dated the 24th of February, 1999, and on October the 27th, 1990. Number 5, 201, number 435, Justice Warner, dismissed, specifically endorsed, writ was struck out on the ground that they disclosed no reasonable cause of action. These decisions have been provided to the Commission.
Thank you very much. Do you recall earlier in this proceedings, when I say proceedings, I mean the hearing, Mrs. Barbara Brown gave evidence, and in giving evidence, a question had been put to her in respect of those matters, that there are matters that had been pursued or brought by the Brown family, and that, words to the effect, my words, that you were successful, that you, Sir John, you are successful in these matters. You'd agree that she gave such evidence?
Gave evidence where?
Before the Commission of Inquiry, under cross-examination being questioned by learned counsel, Mr. Kim White, she had been asked whether or not there are instances, my words, that the Brown family had sought to take you, Sir John Swan, to court. I'm just asking if you recall her giving that evidence.
No, I don't.
Okay. And it's really not a trick question because you're referring to the same documents. What is just a lead up? You just spoke about the documents that you just referred to, the cases, the judgments. They speak to instances where the Brown family has sought to take you, Sir John Swan, to court.
Yes. Okay.
Yes. That's what I meant. I'm not trying to trick you.
And the courts ruled in my favor.
Right, and that's all I'm trying to ask.
Question, I would have said yes.
Okay. And the simple question that follows from that, you'd agree that those matters were before the civil court and not before a criminal court. Agreed?
I don't know the difference between the criminal court and the civil court. The civil court is once against a financial claim and the other one's against a criminal claim. So which one are we referring to? And
I'm saying that you'd agree with me that all the matters that you just listed, the president before that was delivered by the judgment by the president of the Court of Appeal, the matters before the Court of Appeal, the matters in the Supreme Court, they were civil matters of civil jurisdiction, not criminal. That's the question.
I would have to ask my counsel to tell me what I should answer on that question.
Okay.
So Mr. Kim, best answer that question. Assist me in answering that question.
Okay, let me put it another way. In relation to those matters, you weren't charged with a criminal offense, correct?
I was never, as far as I know of.
No, in those matters, that's what I'm saying. Nobody was charged with a criminal offense in relation to those 5 matters you mentioned.
It was a claim. Yes.
Right.
You're right.
Right. That's what I'm saying. It's a civil matter. Now, here in this Commission of Inquiry, the Browns have made allegations in relation to as what they call a series of transactions, a thread of transactions. And you heard certainly what was read to the Commission of Inquiry, an exhibit. The exhibit was CNLB 18. I'm just going to take you to that and take it to the document so I can ask my next question. My apologies, Secretary. It is N17, the one before. It is actually the statement made by, yes, thank you. No, this document was, and I'm going to read it to you, then ask my question. It's dated association with fraudulent activities surrounding the 1968-1969 transaction taken for evidence previously submitted to the Commission of Inquiry showing a pattern of behavior associated with fraudulent activities, March 25, 2021. 1. A fraudulent scheme involving bankers, lawyers, and real estate agents. Robert Mottier of AS&K was the engineer. John W. Swan was a major player within this fraudulent scheme. 2. The 1969 transaction is directly related to the 1970 transaction. The fraudulent transactions of 1968 and 1969 are a crucial part of the basis upon which the 1970 transaction involving John W. Swan relies. John W. Swan is directly connected to both transactions. 3. Russell Levi Pearman acted as an agent for John Swan when the 1969 transactions were being carried out involving JAV and Emmanuel Augustus. 4. Russell Pearman fraudulently submitted a plan to the planning department for a subdivision of the property into 8 lots. John Swan sold these 8 lots to the current residents. We are curious to learn which deeds were used to support a legal claim of clear title to these lands by any of John Swan's clients. 5. The January 11, 1969 sales agreement between JAV and Russell Pearman was fraudulent. Also, the April 15, 1969 conveyance between JAV and Russell Pearman is fraudulent. These documents are used to claim a legal basis for the subsequent sale of the property to Emmanuel Augustus and then on to John W. Swan. 6. Russell Pearman, Emmanuel Augustus, and John Swan visited the property together just before Christmas in 1968. Russell the seller was acting as agent for John Swan, and John Swan was acting as agent for Russell Augustus, the purchaser. 7. The sales agreement for the sale of JAV's land to Russell Pearman was done in the back seat of a taxi at Government Gate up on 42nd Street. The owner and purported seller of the land, JAV, was not even present. This is another fraudulent building block. The transaction between Emmanuel Augustus and John Swan depends on this earlier transaction to support a legal claim to the property. 8. The same documents referred to in item 7 above also contain a witness signature of Algernon Duers. His name appears on more than one sales agreement. However, he was adamant police investigation that he only signed his name once on a sales agreement in the taxi. This is fraudulent misrepresentation of Algernon Duers' signature and is also used to support the eventual claim by John Swan to the legal title of the property. In March 1969, Russell Pearman submitted a plan for subdivision to the Department of Planning for a second time. The first time was in 1968 before he claimed ownership. The 1969 submission contained documents with alterations by hand to the official record. This subdivision into 8 lots of land was the basis for subsequent sales of the property by John Swan. 10. Russell Pearman was involved in 2 conveyances on the same day, April 15, 1969. Firstly, the land fraudulently conveyed to him in 1969 from JAV, and secondly, the conveyance he signed in the sale of land to Emmanuel Augustus in 1969. These transactions involving John Swan's agent and John Swan's client show the relationship that enabled the fraud. 11. John Swan took 7 years to produce a conveyance between JAV and Russell Pearman. This conveyance was not provided to the police when they requested it as part of their investigation. 12. 10 conveyances between John Swan and his staff member Leslie Ming between each other back and forth over 4 days. This is understood to be fraudulent behavior. According to investigator Carlton Adams, this was a wild, wild west. The 10 conveyances were headlined as heads of terms and intent to complete transactions at a later date. 13. Mr. David Kesseram of Cox and Wilkinson penned an article in the Bermuda Sun, February 23, 2001, One Good Deed Deserves Another. This article speaks the relationship between these and how they should link over time. And 14, the bank wrote to Mrs. Brown to inform her that £6,800 had been deposited into JV's account for the sale of his land. Mrs. Brown said that the money had been into the account years after the sale, around July 4, 19, after the case had been closed and because she had asked them about the money time and time again. The bank's Mr. Collier wrote up the slip for sale. David Wilkinson's claim in his statement to police that the payment for the property was made by check, while the lawyer Robert Mottier previously stated in a letter, February 1969, that the transaction was paid for in cash. Do you recall this document, sir? Being read?
I recall the statement being made by,
Okay, thank you. I'm just going to take you back to the top then.
yeah,
And I'm going to point 1 says a fraudulent scheme involving bankers, lawyers, and real estate agent. Robert Motti of AS&K was an engineer. John W. Swan was a major player within this fraudulent scheme. How do you respond to this, sir? Do you reject this assertion?
absolutely.
Okay. Paragraph 2, 1969 transactions directly related to the 1970 transaction. The fraudulent transactions of 1968 and 1969 are a crucial part of the basis upon which the 1970 transaction involving John W. Swan relies. John W. Swan is directly connected to both transactions. It's been suggested, sir, that you are connected to the transaction of Mr. Pearman.
That's absolutely not true.
Okay. You had no knowledge of what Mr. Pearman was doing, of course.
Mr. Perman and Mr. Virgil had no knowledge about their relationship whatsoever. I never met Mr. Virgil, anything.
No, I'm saying you had no knowledge of what Mr. Pearman was doing or did. That's the question.
And I had no knowledge of what Mr. Perman and Mr. Virgil were doing.
Okay. Now, Russell Pearman, you said earlier, did not act as your agent at no time.
That's right. He was never an agent of mine, never represented my company, never employed by my company.
Okay. Take it to paragraph 4. Russell Pearman fraudulently submitted a plan to the planning department for a subdivision of the property into 8 lots. Would you agree with that, having heard the evidence in this commission of inquiry?
What Mr. Pearman did with the property is only became familiar with me when I dealt with Mr. Augustus.
And what is that became familiar? When you dealt with Mr. Augustus, what is it that became, what is it that came to your attention?
It came to my attention that Mr. Augustus wanted me to look at the property from a point of view of him buying it, which I visited the site with him and said it was a good property for development purposes.
Okay, so what I'm repeating to you is paragraph 4, where it says Robert Pearman fraudulently submitted a plan to the planning department for a subdivision of the property into 8 lots. Based on it,
if the word fraudulent in there, that's between Pearman and Virgil. It has nothing to do with me at all.
Okay, having heard the evidence of Brenda Petty, the document examiner, you heard the evidence that she examined documents and formed a view in relation to what had been sent to her.
I'm not here to set in judgment on the assessment of Pearman and Virgil. That is between Pearman and Virgil.
Right. So my question is, did you hear the evidence of Miss Brenda Petty in respect of examining signatures? I'm not finished with my question, sir.
I heard the evidence, Miss Brenda
Not finished.
Petty, and I still mark it as an opinion that I can confirm or deny.
Thank you. Well, let me just finish the question just for completeness. You heard Miss Petty's evidence in respect of the examination of signatures and documents in relation to the sale.
I heard the evidence. I heard the evidence given by Mrs. Petty.
Okay. Thank you. Now, paragraph 4, the second line, John Swan sold these 8 lots to the current residents. You'd agree with me that you sold lots that were as a result of a subdivision done by Russell Pearman? Would you agree with that?
I sold lots of property that I bought from John Augustus, which were 8 lots, which I sold then to members of my staff, or I should say I put them in the name of members of my staff so that I could borrow money, build houses on it, and then those properties then were then sold to persons who might or might not now be the current owners.
Thank you. Just move on. I'm just going to ask you though, when I'm asking a question, I'm just going to ask you to allow me to finish my question. I'm not going to try to talk above you, so I'm just going to ask you to allow me, as I'm allowing you to speak, please. I'd appreciate it. Thank you. Now, the next question, sir, paragraph 5, it says the January 11, 1969 sales agreement between JAV and Russell Piermont was fraudulent. Also, the 1815-1969 conveyance between JAV and Russell Piermont is fraudulent. These documents are used to claim a legal basis for the subsequent sale of the property to Emmanuel Augustus and then to John W. Swan. So the question is, though you're not here to pass judgment, I'm asking you if you have heard the evidence that the documents which preceded the transaction, which is mentioned in JS1, have you heard the evidence that the documentation, some of the documentation, that signatures were forged and the process was fraudulent? Have you heard that evidence?
I heard a statement being made that it could be fraudulent.
Okay. And I return to my earlier question in relation to your concern. Having heard the evidence that, and your words that it could be fraudulent, does that concern you that you eventually have?
I heard it that it could be from somebody else. I did not say that it myself confirmed that it was fraudulent.
Nor did I say that you said that. I didn't say you said that either.
There was a statement made by the Browns, which we all heard the Browns make a statement. You know, and anybody can make a statement. I have no evidence to prove that it was fraudulent.
Okay. Thank you. Chairman, is it a convenient time now?
Yes, Council, I presume you're asking if we should adjourn for 1 hour.
Thank you very much.
Mr. Chairman, could I ask Mr. Harrison how long he thinks it's going to be? We're trying to plan the afternoon and possibly even tomorrow at the rate this is going.
Okay. I don't think I should be longer than 45 minutes.
So
Thank you.
Why can't we finish off at 1 o'clock instead of 12 o'clock?
Yeah, I understand that.
Why are we breaking now when we can? It's only 2 hours. Normally it goes to, the courts go to 12:30, 1 o'clock.
Council haven't heard the obvious disposition that we could continue until 1 o'clock, thereby completing this matter in one go without taking a break. I would ask if any of the other witnesses have any observation as to whether we should break or not. And Council, if you have a specific reason why we should not break, or we can continue.
I'll allow the other parties to come in first, and then I'll return by responding to you, Chairman.
All right, if I could canvass the Browns first of all.
Yeah, we're fine. We're happy to proceed, or we can, we're flexible.
All right, the Browns are flexible.
I'm quite happy to proceed.
So Joan Swan is quite happy to proceed. Ms. Virgil?
Yes, I'm happy to proceed in hopes of finishing this today.
Chair, if I may just have a point of clarification, when we say finish, I presume we're referring to counsel finishing his line of questions, but certainly commissioners have questions and maybe others as well. So at that point, are we talking at 1 o'clock? Are we talking about taking an hour break? Yes, I see Mr. White shaking his head. Okay, I just wanted to get a confirmation on that.
Mr. Stoll.
I need to hear from Mr. Hanson as well, and Ms. Virgil.
Thank you, Mr. Chairman. I think we should finish this if we can until 1.
And Gustavo was saying they didn't get finished by 1.
No, I was referring to
lunch break.
counsel's line of questioning.
That's same as me.
Yes.
We can end the questioning, have lunch, and then hopefully this afternoon people can examine or cross if they wish, and then we can do our closing submissions. Fingers crossed. By the
Ms. Roger?
Yes, I'm okay with that.
Continue till 1.
Yes, I can, sir.
Yeah,
Chairman and Commissioners, I'm having a personal difficulty and I respectfully ask that the adjournment is taken now.
Yes, Council, if it's your disposition that you cannot continue and would absolutely have to take a break at 12, I'll have to agree to that.
Personally, absolutely understood. Absolutely
Yeah,
understood.
we can then return at 1 p.m.
And then continue to get this thing finished, Mr. Chairman, if we can.
Continue from that point on. So we'll adjourn until 1 o'clock as it is mutually agreed. Thank you very much.
Thank you.
Thank you.
All until 1 o'clock.
I would suggest people turn off their mic and their video, but don't leave the meeting because that way you will have to come back in.
Thank you.